Hi everyone. Today I'd like to welcome Adam Hummel to my channel. Adam is a lawyer who specializes in immigration litigation and estate litigation. And today we're going to be talking primarily about some of the issues that international students have been facing with Canadian immigration and understanding the humanitarian and compassionate ground aspect of this part, what it is, how can you apply for it, or what does it even mean? So, Adam, welcome to the channel.
Thanks for having me.
How are you doing today?
Good, how about you?
I'm good, thanks.
Yeah.
Hi, Daniel.
Thank you for having me again, Rabia.
You're welcome. So, Adam, why don't you tell us a little bit about yourself? How did you get into, I guess just to move back, like where did you go to law school? How did you get into immigration?
So I'm an immigrant myself. I was born in South Africa. I came here when I was a
Oh,
kid.
I didn't know that.
Grew up in Canada, so I've always sort of had that affinity with the immigration world. I went to law school at the University of Windsor with Daniel. And after graduating, I jumped into civil litigation, where I worked for a couple of years doing civil litigation with employment law, insurance claims, some family law, and estates law. And in 2016, I decided that that wasn't exactly something that I wanted to do all the time. So I called up my good friend Daniel and I said, I heard you're in immigration law and tell me everything about it. And he said, it's the best area of law you can think of. You should definitely join with us.
I may have exaggerated the truth a little bit.
Now that you think about it, I'd say yes.
Yeah, no. But Dan definitely got me into immigration law. I jumped into it that way. I came to work at the firm where he was working and learned everything I could and have been doing it for the last 9 years or so. So again, it's been nice to work with like in the immigration space because of my own background.
Yeah.
And it's very different than some of the other areas of law as well. I do practice estates litigation also, but it's nice to sort of have a foot in both two different worlds in civil litigation and in immigration because of the different benefits that it brings to people.
Yeah, that's amazing. So how long have you both known each other?
A long time.
You can't count.
Since undergrad, probably.
Yeah.
Okay,
Yeah.
wow.
Yeah.
Wow.
And what type of immigration litigation do you do? Like, is there a special area that you focus on, or what
So
type of applications you maybe see?
for sure. So I guess immigration law, is divided into two different areas of sort of litigation on one hand and processing on the other hand. I don't really do the processing work. I know that's the focus of that you guys do. So rather than doing work permits and PR applications generally, my focus is more on like the more on complicated applications where people are either in Canada who are being removed and who are trying to prevent themselves from being removed, or people who are trying to get into Canada who have maybe complicated backgrounds, who may have criminality, who may have previous inadmissibility issues and things like that. And so in admissibility issues and discretionary applications like humanitarian applications, refugee claims, appeals, judicial reviews, spousal sponsorships where there's some element of that as well. So some of the more complicated cases where they need to be fixed.
So these are, when you do an application for somebody, these are applications where there is a risk of refusal, and your background as an immigration litigator helps you prepare that application, I suppose, in a way that's going to help mediate the risk, or if there is an application that is refused, you've set it up in a way that maybe will help fight that case in court if necessary. Am I getting it? Okay.
Yeah, that's right. I think there's one of the ways I sometimes describe it is like there's checklist immigration and non-checklist immigration.
Right.
So some of the processing stuff is you have a checklist and you have to go through it, and if you tick off all those boxes, then you'll get welcome to Canada. The stuff that I do is largely non-checklist, where there's a discretionary element to it, where someone can put in their application, but you really have to try to either tug on the heartstrings of the officer who's going to be reviewing it, or try to use something like humanitarian and compassionate considerations, which we're going to be talking about, to try to, again, convince someone that, either you should be allowed to stay or you should be able to get into Canada for whatever reason.
It sounds almost like there's more of an art to it than a science. Is that another way of looking at it?
Yeah. I think, with all law, I think there's a lot more of an art than science. But yeah, definitely. There's an element of some creativity and strategy and things like that as well.
Yeah. A lot of people ask me about humanitarian, like they read up online, like if, for example, if they can't find a way to permanently be in Canada, so they'll read up on this stuff. But I wanted to ask you, like, what is humanitarian and compassion? Like, how would you describe it to someone who has no idea what it is, or how would you describe it to a child? I'm gonna ask him the same question.
Yeah. Okay. So, firstly, it's so there's humanitarian and compassionate provisions in the immigration legislation. So, Section 25 of the Immigration Refugee Protection Act, the IRPA, does carve out an exception for humanitarian and compassionate considerations when it comes to permanent residency applications. Now, that's what it says in the law. What that actually means is that there is a case to be made where you can make these claims on a humanitarian and compassionate basis, where you're basically trying to say that, if you are to put these facts to an objective observer, to someone who's reasonable and objective in all respects, that they should feel, compelled to try to help, to try to alleviate the suffering of someone based on those considerations. And so, I'll get into what the legal tests are and things like that. But it's really this idea that someone is facing some difficulty, and the humanitarian and compassionate considerations are an opportunity for an officer to kind of look past the checklist and look past some of the strict guidelines, and to try to apply some goodwill or some judgment to try to help someone alleviate their suffering and to try to allow them to become a Canadian permanent resident.
It sounds highly discretionary. Like it's almost as if that you're trying to convince an officer when you submit this application for humanitarian compassionate grounds consideration, I suppose. Are there rules to follow though? Like the officers are guided by certain principles, or is it just whoever you get? And if you get an officer who finds that it's a compelling story, you win, and if you don't, you lose. And can you even choose your own officer? Like, how does that work?
Yeah, it's a great question. So, usually when I talk to people about it, I say that in some sense it's the luck of the draw. Because it's a discretionary application, everyone naturally just exercises their discretion in different ways. So sometimes you get an officer who is incredibly strict and who is very deferential to the guidelines, and who just looks at it that way. And in other cases, you may get an officer who's far more compassionate and who has a lot more of an understanding of what the circumstances are. There are different tests depending on the type of application that come from the jurisprudence and from the case law, where it basically says what you should be considering in terms of these different applications. But again, I think the way that I often describe it to some of my clients is you want to try to tug on the heartstrings of whoever is going to be reading this. And in some respects as well, with the humanitarian application, you want to try to throw everything at the wall and try to see what sticks. Because this is an opportunity for you to really make your case with as many of the factors as you can to try to compel a positive decision to be made in your case.
And can anyone just apply for it? Like, do you need to do something beforehand to initiate it? Do you need like an invitation? I mean, a lot of people are focused on receiving invitations for example, the express entry system, provincial nomination. How does that work? Can you just apply, or do you have to wait for the government to do something?
So it's a great question. There's basically two ways that you can use humanitarian and compassion arguments. There is a straight up H&C, like when I use H&C, it's humanitarian compassionate. Sometimes people don't understand. Sometimes people think I'm saying agency. One person said, "Why do you keep saying 843?" Okay. I'm saying H&C is humanitarian and compassionate.
Right, the letter H, the word and the C. Okay,
yeah, exactly.
Got it.
So an H&C, there is a standalone H&C application, and then there are other cases where someone could be applying for permanent residency, where you can make H&C arguments within that application. So let me give you an example. So you may be applying for let's say a spousal sponsorship application, and there may be a situation where you may be inadmissible for some reason, or there may be some other complication that has come up. So, and in the context of that specific application, you may not strictly be eligible, or there may be something that is stopping you from being permitted to be landed as a permanent resident. So let's say in some cases you are applying to sponsor a spouse, but in the past you became a permanent resident and you failed to declare that person as your spouse in the past.
Right.
That may result in a case where, in strictly speaking, you would not be allowed to now sponsor that person for sponsorship.
You failed to tell the government about it
Yeah,
when you
exactly.
applied, so now they're saying you cannot.
Exactly.
You can't.
And this happens a lot with, I don't want to get too off track, but this does happen a lot with people who are in like a common law relationship. They may not know that they're in a common law relationship because they've lived with them for a year. And they've then applied for permanent residency. If they fail to add that common law partner on their PR application, then strictly speaking, they are not allowed to sponsor them later on.
Oh wow. Okay.
We've seen that too. Like people sometimes forget to disclose common law relationship.
Well, yeah, it's a unique
Yeah, it's-
concept.
yeah.
And, for,
Exactly.
We'll see clients that are in the United States. They've gone through the U.S. immigration system. They're there on temporary visas, and they'll be living with somebody, and they're in
For a while,
and there's no equivalent. They're familiar with spouses. They maybe come from cultures or backgrounds where this concept of common law doesn't really exist because
Exactly.
you're either married or you can't live together as spouses, or they're same-sex partners, and they didn't even know that was a thing in Canada. So I've seen those before. And so you're saying that if one of them applied for permanent residency, Canada would consider that relationship to be a marriage-like common law relationship, and then if they didn't tell the government about it, they're now excluded from sponsoring them.
Yeah, so I'll give you an example, the best way to illustrate it. A couple years ago, I had a couple from the Bahamas. They were here, they were working. They were not married, but they were living together in a spouse-like relationship for over 1 year. That made them common law partners according to the immigration regime here. It wasn't a husband, I guess the boyfriend, he applied for permanent residency on his own because he was eligible, but he didn't include his girlfriend on the application. He became a permanent resident, and then a couple years later, he sponsored his girlfriend to become PR as well, and he got a letter from IRCC saying, we see here from the information that you were living in a common law relationship at the time that you applied for PR, so you cannot now sponsor your partner because she is excluded from being sponsored. So what we did is we responded and we put everything in, and we included humanitarian and compassionate grounds to basically argue that he didn't know that they were in a common law relationship, and he didn't realize that by the time that he had applied, they had actually, magically become common law partners according to immigration law that they didn't understand.
Yeah.
And we basically put in our submissions and H&C submissions that said, they're well established in Canada. They would face hardship if they were to go back to the Bahamas, and for that reason, we were seeking to have them overcome any of the exclusions to get landed. And so we used humanitarian and compassionate arguments to try to get that sponsorship application over the finish line.
So that's, I guess, case type 1, where you're using humanitarian and compassionate grounds arguments to try to convince an officer to allow something that otherwise wouldn't be allowed. But you mentioned there's this other case where you can just make an H&C application. So for example, if you have somebody here, they were studying here as an international student, they graduated from a program, they've been working in Canada for now a few years, so they've been now, let's say, 4-year degree, 2 or 3 years of work, but they're looking at the express entry system and they're seeing that their points aren't high enough to get an invitation, and they can't seem to get selected in their provincial nomination program. A lot of our clients come to us with these fact patterns. Is there a way that they can, they're not inadmissible, there's nothing, they're here legally as temporary residents, but they've been here for so long, they just want permanent residency, and they feel like, all the time and money and effort that they spent in Canada now, 6, 7, 8, 9 years, they're looking for something in return. So what can somebody in that situation do? Is that the case type B that you're referring to? Okay, so how does that work?
Okay, so like I said, there is the second type is a standalone agency application. It's basically an application for permanent residency on humanitarian and compassionate grounds. And the way that I like to describe it is, it is and it should be considered an application of last resort. It's if you are not eligible for anything else. If you are not able to, if you don't have the requisite points after the time you spent in Canada to be able to apply for express entry, if you are here with an excluded spouse, or excuse me, if there's something that's excluding you from applying through any other way, or if you're too old to get the requisite points for express entry, then there is this opportunity to apply for PR just on humanitarian and compassionate grounds. It comes up a lot in these circumstances where it's either last resort, or it's people who may otherwise be inadmissible, people who have lost status for some reason, who have overstayed their stay, who've been in Canada for time without valid status. This is an opportunity for them to try to rectify the situation and become permanent residents on humanitarian and compassionate grounds.
Yeah. So I just have a question. So for example, if I'm an international student and I came to Canada, I don't know, maybe like 5-6 years ago, and then I graduated, but I found out that I may not be able to get permanent residency because of all of the changes, and then I enrolled myself in another program just so that I could stay here. And I've been here, I don't know, maybe like 7 to 8 years. So can that person consider permanent residency through this pathway, humanitarian and compassionate, or?
Yeah, absolutely. So if you were to come to me and say that, Adam, this is my situation, this is what I'm looking at.
Yeah.
I have no other way of doing that and no other way of going through it. This is how I would explain it to you. Again, I would start off by saying that a humanitarian application should be an application of last resort. It's if you've already, because the officer who is going to be assessing your application is going to look and say, is there any other way aside from this that they could become a permanent resident? Or even if they can extend their temporary status in some way as well, until maybe they can hypothetically become a PR through other means in the future.
Okay.
But then what I would say is I would look at the test. So there's basically, and then Dan sort of alluded to this earlier, is there a legal test for an agency application? And the legal test looks at 3 different factors for a standalone. It's what is your establishment in Canada is the first one. So, and again, it's no like hard and fast rule, but establishment is generally considered by asking a couple different questions. It's how long have you been in Canada? Have you been working here? Have you been self-sufficient? Have you been able to support yourself? Have you been responsible with money? Have you made friends? Are you integrated into your community? Do you volunteer? Do you go to church, synagogue, temple? Are you established in a way that someone could generally be considered as established in Canada? So again, that is definitely more of an art than a science. It's not like 3 years you're established.
Strong roots, it sounds like.
Yeah, exactly.
Yeah.
Okay.
So establishment is the first factor. Second factor that will be considered is whether you might face hardship in your country of origin if you were to go back home. So if you come from a country, the most extreme examples, Somalia, for example, or Iraq or something like that, where you would consider generalized hardship conditions. So environmental factors, employment factors, crime, security, safety, things like that. If you're a woman and you might face gender discrimination, difficulty getting a job, employment opportunities, and things like that, that can all speak towards hardship factors as well. And that is absolutely something that is considered with an agency application. And then the third big factor is whether it's in the best interests of any children who may be impacted by the application for you to stay here. So do you have any children who are either born in Canada or who came with you to Canada who have been raised here? Are you taking care of any children here? Do you have children abroad who you're sending money back to? And that it makes more sense for you to stay in Canada to earn money and send it back there? It would be in their best interests. So those are the ways that basically the establishment, hardship, and BIOC, best interests of the child, can come into play here for the legal test for an agency application.
And is there like a time frame that you would normally recommend that a person be in Canada first, or is it? I mean, how quickly can one really establish all those factors? Do they have to meet all of them? Or is it not so clear?
Yeah, look, it's very I guess the time related factor is the establishment. Again, I think just from my experience, there's no hard and fast rule. Again, with like you have to be here for at least 3 years to be considered established.
Right, no checklist.
Yeah, exactly. It's sort of like the how much what you actually spend doing, what you actually spend time doing while you're in Canada during that time. And again, there are people who 3 years is totally sufficient to establish yourself. There's other people who, you know, it makes much more sense 10 years that they spend time working and doing all of that. With students, it's really interesting because in some respects, students are, you know, there's the rule for establishment is not, you don't have to show exceptional establishment.
Okay.
You don't have to show establishment that is, you know, more established than than average Canadian or something like that. But you do have to show that there is some element of, you know, it's not just that you come here and you've done what you need to do and that's it. So for students, for example, it's tricky because a lot of students come here and you live as a student. You do what students are supposed to do. You go to class, you study, you spend time, you know, at the bar and making friends and things like that.
Yeah.
In some respects, if you just apply for an agency after that, it may be considered that you haven't done anything, you know, particularly either exceptional or more than usual to establish yourself. But you just came here to do what you did, and that's it. So again, I think like it's important in some respects, if you are even considering that, to really think about your establishment and the ways that you may be able to set yourself apart in that establishment rather than just going to class, integrating yourself in clubs on campus, in your broader community and things like that.
Yeah. So it sounds like it's a story for these types of applications, and like how you're telling that story and what have you been doing since you moved here.
Mm-hmm. The story is important because one of the elements of an agency application is putting together like a solid affidavit or statement, which basically tells your biography. And if you can tell a compelling story, it could be a big difference.
I mean, I'll have clients come to me and they tell me that they had to sell assets, they uprooted their whole lives to come to Canada to study for a few years. And then they're now finding out that the rules of the game are changing, that maybe they're not eligible for a post-graduation work permit. You know, or in many cases that they were eligible for a post-graduation work permit, they've been working, they've been struggling, but they don't have the right job anymore because the Canadian government now is focusing on selecting, as opposed to general skilled workers, those who work in specific occupations, or if you speak French, I suppose, you have another pathway. And what they've done, though, is they've been students, as you said, and they have relationships, they have friends, and then they go to work, which for a lot of young people, you know, in their early mid-20s, that's enough, right? I don't know if there's a higher expectation of Canadians, but what I kind of hear you saying is that while you don't have to be exceptionally established, you still have to do more than what seems like, I don't want to use the word bare minimum because it seems like a lot, but it's almost as if they have to do more, but not exceptionally more. So where do you, is there like where do you find that distinction? Where do you draw that line? Like, how do you get into like the nitty gritty of a case and say to a client, yeah, I think this would work, or maybe this wouldn't work. Maybe you should do X, Y, and Z to further establish yourself in Canada.
Yeah, I think it's tricky, and it comes with, you know, getting a sense of having some experience and understanding it, and I think that's also why it's important, if you are considering this, to talk to an experienced immigration practitioner who has experience with it and who knows from before, because I have had some cases where people, you know, just come and say, okay, I've done a couple years, I'm ready to make an agency application, I'm not going to qualify for anything else. And that's not, you know, the way to approach it. Again, I think, like I said, it is more of an art than a science, and I think that there are some factors that if you talk to someone who has some experience with this, they'll say, you know, these are some of the things you can do to better establish yourself in Canada. These are some of the ways that you can improve some of the relationships you may have, to contribute to the economy a little bit more, and those sorts of things. So it is important to do this in a holistic way, because that is the way that it is going to be assessed. It is holistic in nature. It is looking at all these different factors together and basically saying, and the assessment by the officer will be, taking all these factors into consideration, ultimately, does this person deserve to stay in Canada as a permanent resident? Are they, it may be sympathetic and there may be humanitarian and compassionate grounds, but at the end of the day, they want to know, is this person going to continue to contribute to Canadian society and specifically to the Canadian economy? And they want to use, it's not just showing the experience that you have, it's showing that you have that experience as a way to show that you will continue to be able to contribute in the future.
Oh, I see. So if you're like an international student who's graduated on a post-graduation work permit, let's say you study for 2 or more years, you have a 3-year permit. What point would you recommend that a person apply? It sounds like you don't want to do it too early, but also what happens if you apply with only like a couple months left on your permit? Like, can you stay while you're waiting for the decision? Like, so how does somebody balance, I guess, those considerations? Being able to show that they've done all they can without waiting too long, that not suddenly they're worried about losing their ability to work in Canada and all that establishment, I guess, evaporating, or maybe they can stay. I don't know.
Definitely. Yeah. So it's a great question. Firstly, I think the most important thing to say first is that we are all very sympathetic to how unforgiving the Canadian immigration system can be.
Right.
It is very difficult in some cases in the system as it is now to overcome errors and mistakes that may be made. Yeah. And in some cases, there's supposed to be programs that are designed to get people on a track to permanent residency that don't always work that way, and that are unforgiving, and that are difficult to overcome in some cases. And it's incredibly frustrating, and it's a conversation I feel, and I'm sure you guys do as well, I have with every day with someone.
Yeah, we've been having them too. Yeah, literally every day.
So for postgrad work permits, for example, like it's supposed to be that you can come to Canada, spend lots of money getting a Canadian education, and then you should be on a path to be able to get that postgrad work permit. But some of the rules of the postgrad work permit, for example, are, if you have one semester that you were sick and had to drop a course, which puts you into part-time work that semester, that could jeopardize your ability to be eligible for postgrad work permit when you apply for it.
Interesting.
Yeah.
And so it's those sorts of things which are really difficult. It shouldn't be the case that jeopardizes all your experience in Canada.
You can choose to get sick. You know.
Exactly.
Take your semester.
And or people fail courses sometimes, which happens to every student, whether you're Canadian or not.
And also, I think it's a transition too. If someone's moving from one country to another, people may have like mental health issues, or they're having a hard time adjusting, so they could they can take a break.
Yeah, absolutely. Yeah. So these are situations that a lot of international students are facing, and again, like they'll apply, and then they can come up against an officer who's either particularly stringent with the rules, or who doesn't want to read outside of the corners of the guidelines,
right.
Or who misunderstands it as well and misapplies the rules in some cases. And so in that case, it may be required to try to turn to something else, another option. So to answer your question properly, when you get to that point, again, I think it is important to have that proper conversation with someone who can properly guide you on what your options are and could be, and whether there are other ways that you can try to either rectify your status or extend a work permit, for example, or something to get you to the point where you can make, an express entry application for PR or something a little bit more straightforward before you go to an agency application. Mm-hmm. Otherwise, it may very well be that an agency application is the way to go, and that would be the best thing for you. Now, the problem, there are a couple problems with agency applications, and I might as well address them now. There's two big problems that I always talk about. One is the processing time, and the other is the fact that it doesn't get you back into status. So let me go through those. So the first is the processing time. An agency application, a standalone agency application, can take upwards of 2-3 years to process.
Wow. I don't think any of the economic ones can take. I mean, maybe a few now.
Yeah, I don't know.
2 to 3 years? Okay.
Could be provincial nominations in some cases, federal business.
Self-employed person's class.
Yeah, self-employed person's class.
That's the one that I've seen.
Those ones take a long time. But that's a long 2 or 3 years. It's a long time to,
it's a really long
to wait
time.
On an answer to the question of, this is my application of last resort, can I stay? sure, we'll tell you in 2 to 3 years. Like that's almost cruel when you're filing an H&C application.
If I'm still alive by then.
Yeah, well, hopefully.
It's one of those things like you never know,
wasn't
right?
going
like,
there. But
Yeah. I mean, they could be.
I meant still
or
employed.
any
You said the status issue. So.
Oh, for sure. So I mean, so again, like, it can take a really long time.
Yeah.
Right. And in that time, literally anything can happen.
Yeah.
But the other thing is that an agency application, it doesn't give you that implied status. So, as you know, when you are here on a work permit, for example, if you apply to renew your work permit, then you go into something called implied status, which means that you don't actually have a permit that says when your status expires, but it extends your status until a decision is made on that new work permit.
So you can keep working.
You can keep working, and you have that implied status either until your next one gets refused, or until the next one gets approved and that one expires.
Yeah.
If you apply for, if you are on I think the example used before, Dan, was that if you are on a postgrad work permit that's going to expire, and you apply for, and you have no other choice, and then you apply for an H&C application, that is not going to get you into implied status past the date when your work permit expires.
Okay.
All it's going to do is put an application in, and it'll start the application process.
Yeah.
But it's not going to maintain that status for you. And so in many cases, if someone applies for permanent residency on H&C grounds, they still have to figure out another way to maintain their status, whether it's as a worker or a visitor, while their H&C application is still pending.
So is there an option? So I know for express entry or some of the provincial programs, we have this option where you can, if you've applied for permanent residency, you can apply for a bridging open work permit.
Yeah.
Is that also possible in this case?
It's not possible
Not
to
possible.
an H&C application.
No way to bridge that gap.
No. And a bridging open work permit, again, I think you guys are better, more knowledgeable about it than I am, but it's for if you're specifically applying for a PR application.
Yes. Yeah.
That is basically like one of the that's not a discretionary application.
Correct. Okay. So.
And so that's what's really key. And so the thing is that with an H&C application, it can be processed and it can be approved if you've fallen out of status, if you've lost your status in Canada. In fact, again, one of the main reasons why people apply for H&Cs is because they are out of status.
Oh, I see.
And they have no other way of doing it. But firstly, I always try to encourage my clients to make sure that they stay in status. Whatever necessary, because it helps. But that H&C application is not going to get you in status. And also, it's not going to stop you from being removed from Canada necessarily if the CBSA decides to take enforcement action against you.
It will not stop you. The CBSA.
It's not on its own necessarily going to stop you.
Right.
It can help. I don't know how much you want to get into it now, but it can help if there is enforcement that is taken to try to stop a removal. But on its own, if an H&C application is pending, that is not going to necessarily stop you from being removed from Canada.
So if somebody is on that 3-year postgrad work permit and they're hearing 2 to 3 years, I mean, my first reaction is, wow, I don't have status, so I should apply for this like almost right away. But then I haven't really given an opportunity to allow myself to qualify for express entry. So I'm going back to this sort of battle between how much time do I have to work in Canada to demonstrate to an officer that I've done what I need to establish myself in Canada, and not filing my H&C too late. Or is there a way maybe that you can apply for a temporary permit of some kind to get a work permit, or at least be in implied status for a while you're waiting for H&C? I'm just trying to understand if there's anything that somebody can apply for to try to bridge some time.
Yeah, listen, it's an imperfect solution, and it is challenging in its own different ways. So, like, if someone's here on and the problem is that the processing time can vary. So
Right.
It can take 2 to 3 years to process.
Okay.
But in some cases, it can be shorter. So, for example, if you are on a 3-year like I actually had someone call me the other day and say they're here on a postgrad work permit. They don't know if they're going to get the requisite points to be able to qualify for express entry later on. Can they just apply for on humanitarian and compassionate grounds now? And I said, you shouldn't, because if you submit your application, it's a big application, an agency application too. It's a really big, fulsome application. It takes a lot of time. It's expensive to do a good one, and it takes a long time to put together. You could go through that whole process and put that in, and it could go to an officer who can look at it and say, this person still has 2 years on a work permit in Canada.
Right.
Yeah.
Okay.
Refused. There's absolutely no grounds for this. They're still here.
Right.
Then you've wasted all that time and money putting something in when you still have that opportunity. And so again, it is really important to consider that it is supposed to be, and it is generally looked at by officers as an application of last resort, which makes it complicated and which makes it imperfect, because timing never really is a perfect time to do it. But there are other things. There's other options, like you mentioned before. There might be a temporary resident permit that you could apply for, which is a temporary resident permit, a TRP, is it's a way to rectify your status or get you into status if you are otherwise inadmissible in some way to Canada. So if you've maybe fallen out of status and you need to get your temporary resident status back, you could apply for a TRP. In some cases, if you get that TRP, for which you really have to show like a need for it.
Mm-hmm.
But if you get that, then in some cases, if you get it for a minimum of 6 months, you could also qualify for a work permit. But again, a TRP is also a highly discretionary application, and it's different than an agency because it's only temporary residency. It's
Right.
not a PR application like an agency application is.
Okay, so if I've been in Canada now and I'm here for, I don't know, two and a half years on my post-grad work permit, I've acquired a couple of years of Canadian work experience, I've graduated. Sounds like I've made the effort now to try to qualify for permanent residency. So I've done my language test, my points are great, historically speaking, but horrible in today's current environment. 6 months is left. Maybe now is the time to consider filing that H&C. The needle isn't really moving over the next 6 months, probably. Maybe file that H&C. I'm coming to the end of that 6 months, and I say I still want to be able to work. I've got a job. Is there a way of saying like, well, I filed my H&C, now the government knows I want to stay permanently. Can I file a TRP and say, yeah, I know I haven't fallen out of status yet. I don't want to wait till I fall out of status because then it's going to be a mess to convince my employer to keep me working.
Yeah.
So I'll file this TRP and say I recognize that I really don't have true temporary intent. I've run out of all my options, and apply for that with a work permit of some kind. You said you can get a work permit that's longer than 6 months. Is that work, or is that kind of a weak basis?
I think that's the thing. I think it's every case is unique, and
right.
I want to be very careful not to mislead any viewers or anything like that.
Yeah.
But there may be different ways to be creative or I don't know what the right word is, chutzpahdik, like nudgy, to try to see what you can get away with.
Right.
The idea of it's easier to ask forgiveness than to ask for permission, sort of thing. But there may be ways to try to apply for an agency in the long run to get PR, while at the same time applying for a TRP to at least temporarily extend your status, and at the same time as applying for the TRP, applying for a work permit on that basis as well. There may be different ways, and there may be ways to be creative with that. But again, it totally depends on the circumstances.
Like sometimes what we'll do is we're working with clients, and we could be in a situation where we're anticipating applying for permanent residency under an economic program. And so we know that, hey, they're not actually eligible for a bridging open work permit today, but we expect maybe when we file the application next month, when we finish getting the documents, that we will be. So we'll sometimes file the bridging permit because they're running out of status and tell the officers, by the time you're reading this. It doesn't always work because of the processing times. You can have an officer that says, wait, you filed it, and you don't have that PR application in process, so they refuse it.
Mm-hmm.
But at least from what I'm saying, work permit processing generally takes kind of a few months. And we're not really being disingenuous. We're telling the officers that we anticipate filing something. Or we'll have like a permanent residency application that was submitted, and then it gets refused.
Yeah.
And now that person's bridging open work permit is still pending because it's taking 5-6 months. They filed their PR, and they got a decision 4 or 5 months in. Express entry is pretty fast. I'm wondering if there's sort of something analogous in the situation of somebody who is, filing an HNC, and then they file maybe a work permit on TRP grounds. I don't know if you've experienced, how long does that take?
Yeah, listen, I don't think it's incorrect to say that you could hypothetically apply for, like, if you have a work permit of some kind, if you have an open work permit, let's
Right.
say,
Yeah.
that you don't need an LMIA for,
Right.
that
Okay.
you could apply for, if you have a real need, like, again, the test for a TRP, and again, I don't want to get too much into TRPs in talking in this conversation, but
Right.
the test for a TRP is basically where it's need-based versus the risk that you bring to Canada. So
Oh, I see.
if there's a real need for the TRP, then that will be considered. So I don't think it's incorrect to say that if you have an open work permit that you need to hypothetically extend in some way, you could try to apply for a TRP and a work permit at the same time.
Can the need be employment? Like your employer is expecting you to continue working. You've got projects that you're working
Maybe,
on.
yeah.
Okay. So there's
Again, a TRP is also discretionary.
okay.
And so that that could totally depend on it. And so I think you could, in some respects, say you apply for a TRP with a work permit as well. You ask for the TRP to be issued for a minimum of 6 months, because you're only eligible for a work permit with a TRP if it's a 6-month TRP or more.
Yeah.
You ask for that. You are then technically in implied status until that is decided. If it gets refused, then that's when your status expires. And if it gets granted, then good. Then you've got an excellent lawyer.
So when you file an HNC application, is it all approved once at the end, or is there stages to the processing application, and how does that affect a client's prospects for staying in Canada?
You've been working in immigration longer than I have. You know that they would never make it that easy.
Right.
I can say that too now.
So it's done in stages.
Okay.
What you do is when you apply for an HNC application, it's the way I like to describe it is it's basically two parts. It's an HNC application for permanent residency, and it's kind of processed in that way.
Okay.
So in the first stage, and the way it's not really broken down in any like even way over the 2-3 years sometimes that takes to process, but it's basically processed in that way. The first stage, you put your whole application in at once. It is just applied for as one application. You put the whole thing in, and it usually consists of 4 parts. An application. It's forms, immigration forms. It's supporting information and documentation. It's an affidavit, like I said before, basically a story or biography of why you deserve this, and then fulsome legal submissions as well. You put in your whole application package. Nowadays it's submitted online. It goes to be processed in the Vancouver office. After some time, usually about 18 to 24 months, you'll get a decision from immigration which will basically say that they have approved your application for processing from within Canada. What that means, it's approving your PR application for processing within Canada, which means that you've overcome the HNC or the Humanitarian and Compassionate hurdle. They have agreed that they will continue to process it, and
within Canada.
From within Canada.
Oh, I see. Okay.
Now that means that they will process it as a PR application. So that's really the big obstacle that is overcome.
Yeah.
And usually, again, when I the celebratory phone call that I have with clients takes place when I get that first letter that says your HNC application has been approved for processing within Canada. They are now going to, and it's now what I call AIP, approved in principle, and they will now take the steps to basically cross all the T's and dot all the I's and make sure that the PR application itself, the permanent residency application, can be processed. So that first stage is really important, again, because you basically overcome the biggest obstacle. That discretionary element to it has been overcome.
You've demonstrated that you are deserving of humanitarian and compassionate consideration. Okay, got it.
The other thing is that at that point, you are now eligible to apply for a work permit, which is great.
Okay.
Because if you are out of status now, it means you can apply for a work permit and get that work permit and start working. And the other thing is that you can also apply at that stage generally for health insurance. Like if you're on Ontario, OHIP, and you can get that health coverage while your PR application is in process.
Okay.
And then over the next little while, however long it takes, you may get another letter that says we need you to do an updated medical examination, we need updated financials, employment documents, and maybe biometrics or something like that. And then when you submit that additional information, they will continue to process your application, and then after some time, you will get your confirmation of permanent residency. So that's the sort of structure that works. It's kind of in those two stages. It's also why it takes so long, the 2-3 years to process. But again, that first stage is really the big hurdle to overcome, which is once you get that, then it's more likely than not that you'll get your
And
PR.
is the first hurdle takes the longest? Or
Sometimes.
Okay.
Usually it does.
Okay.
It does.
And once you get to that stage, you had mentioned before that somebody who is out of status or they fall out of status, they don't get an extension. But when you apply for the work permit, it puts you back into.
That's right.
Okay, and what happens to potential enforcement action? Can you still be removed if you're waiting for the work permit, or you have that AIP approval in principle?
Yeah, so it's a great question. Basically at that point as well, it makes you it would stop any enforcement action if there is enforcement action against you, or it is unlikely that or it is all but impossible that you would be removed after that first stage.
Okay, so
Because basically you're
maybe
now
a technical reason why someone might be, but practically speaking,
exactly.
Okay.
It's very, very, very unlikely that, and in some cases I've had clients where they've been. I have a case right now where clients are in the midst of being removed from Canada, but they do have a pending H&C application, so hypothetically they could still be removed while that is still pending.
Right.
What I'm hoping is that IRCC makes a decision sometime soon, and if it gets approved, then I know that CBSA would back off immediately.
I see. So you have basically the immigration department sending a message to your client that they've been approved in principle, and it also sends a message to CBSA, whatever reasons, unless they've changed, that you were going to remove this person. Hold on a second, we're considering granting them permanent residency. So don't rush to.
It's more likely than not they are going to become permanent residents, so there's no point in taking this step.
Right. Okay.
Yeah.
All right. So it really does sound like a harrowing experience if somebody is in Canada and they've been here for a long time, they've established themselves, and now they're coming to the end of the road.
Yeah.
So I can imagine how anxious or nervous clients are going to be during this period of time. What do you say to them or their employers? What to expect over the next little while? How would you sort of address that with them?
Listen, right now in Canada, everything feels like it's in flux.
Right.
There's a lot of uncertainty with the government, with the different programs, and with the way that the current government or future government is prioritizing certain immigration programs over others. It is leading to uncertainty in every field, and especially with immigration lawyers and with potential immigrants as well. But there is, there are. One of the reasons why it's important to have conversations like this is because there's a lot of nuance and a lot of complexity to a lot of the different options that are available to people who are in this position and who are looking at options to either stay in Canada temporarily or permanently. And so, H&C application, some people have heard about it. There's a lot of nuance and a lot of complexity to it. And I think it's important just to know that it is an option, that it is something that you may be eligible for. And as a last resort, in some cases, there are lesser and lesser options to pursue, and so this may be the best option for moving things forward. Like with everything, there's a balancing act, and so if a lot more people are applying for agencies, the processing time may get higher than 2-3 years.
Yeah.
Or if they're processing fewer applications, I hear that.
Exactly.
Immigration targets.
Yeah, and so, but anyway, it's important to know that there are different options, and it's important to be able to speak to someone properly about it and to see what your chances are.
Yeah. So I think this was really insightful, and from what I'm hearing is that the agency applications are quite complicated, and I think it's best to just at least speak to someone to get an idea of what it is, and whether you can or cannot apply for it. So thank you, Adam, for your
Thanks for
time.
having me.
And thank you, Daniel. Do you have any other last things to say? Or
No, listen, I've been practicing immigration for 12 years, and it sounds really complicated in
Yeah.
HNC. So I wouldn't do it without a lawyer.
Yeah.
That's for sure.
All right. Well, thank you for watching, and we will see you next time.
Thank you.
Thanks.